Morning had already settled over Bonanza by the time the call brought deputies to First Avenue. But the house did not seem awake. Nothing about the property suggested noise, struggle, or panic from the outside. It stood there, in the plain daylight, with the stillness of a place keeping its own secret. No movement at the windows, no hurried footsteps, no answer coming from inside. Just a home that should have held the ordinary sounds of a mother and her children, and did not. According to the Sebastian County Sheriff's Office, deputies were sent for a welfare check at about 9:30 a.m. on December 3rd, 2025. What waited beyond that door would turn a quiet Arkansas morning into a case that still refuses to leave people alone. This is the kind of moment that forces a question before the facts even have room to line up. How does a house go silent, so completely that the silence itself becomes the alarm? Have you ever felt that sudden drop in your chest when someone who should answer simply doesn't? A missed call can be nothing. The locked door can be nothing. Delayed text can be nothing, until one detail presses against the next. And what looked small begins to feel wrong in a way your body notices before your mind is ready to name it. That is where this story begins. Not with speculation, not with rumor, but with a welfare check requested because something had gone off course enough for somebody to seek help. Before we go farther, take 1 second to do what helps channels like this survive. Subscribe, leave a like, and tell me in the comments what detail unsettles you more, the unanswered door or the fact that somebody felt strongly enough to ask authorities to come check. Real cases deserve careful telling, and your engagement helps keep that kind of storytelling alive. Deputies reached the home and got no response. That detail matters. People answer doors half asleep, irritated, distracted, late for something, busy with children, halfway through breakfast, or carrying groceries from the car. Houses answer in some form. A voice through wood, steps across a floor. Dog. A television turning down. Latch. Here there was none of it. Reports say deputies entered the residence and found Charity Beallis, age 40, dead inside the home, along with her 2 young children, widely reported as 6-year-old twins. Authorities said all 3 had gunshot wounds. In a matter of moments, a welfare check became a homicide investigation, and the stillness outside gained its meaning in the worst possible way. It is one thing to hear the phrase family tragedy and let your mind place it in that vague box where terrible news gets stored. It is another to stop and sit with what was actually found. A mother and her children inside the place where they were supposed to be safest. No public wording can soften that. No headline can carry the full weight of a scene like that. The structure of the house remains the same. The address remains the same. Daylight still falls across the property, but the meaning of every room is altered at once. That is the first shock this case delivers, not only because of death, but because of where the deaths were discovered, at home, after the home itself had already started telling the outside world that something was terribly wrong by offering nothing back at all. But this case did not grip the public only because of what deputies found on December 3rd. It gripped people because of when they found it. Multiple reports state that Charity had attended a final divorce hearing just 1 day earlier. 1 day! The courtroom came first. The deaths came next. That timing lands like a blow, because it changes the shape of the story immediately. What could have been received as a grim local headline became, almost at once, a larger question about danger, timing, fear, and whether the most important warning signs had already been present before anyone stepped through that door. The house would not answer on Wednesday morning. By Thursday, the whole country was asking what had been building before the silence took over. That is the conflict at the center of this opening. A mother was found dead. Her twins were found dead. The discovery came one day after a final divorce hearing. Those facts are enough on their own to seize attention, but they also demand patience. Real stories like this are damaged when people rush to fill every blank before the evidence does. So this chapter stays with what is verified: the welfare check, the entry, the bodies, the gunshot wounds, the hearing the day before. No invented villain, no borrowed drama. The truth here does not need decoration to hold your focus. It already carries more weight than most fiction could manage. A welfare check is by design an act of interruption. It starts with uncertainty, not proof. Someone is not reachable. Something feels off. Officers arrive prepared for possibilities that range from harmless misunderstanding to medical emergency to crime. Most people hope for the first option. Open the door, apologize, explain the missed calls, let everyone leave relieved. That expectation is part of what makes this case hit so hard. The outcome moved in the opposite direction. Instead of relief, there was confirmation of death. Instead of a brief knock and leave call, there was a crime scene. Instead of answers, there were the first hard facts and a widening field of questions. And even now, the opening image remains difficult to shake. Daylight outside, no response inside, officers crossing the threshold, and a family's world ending in public record. That contrast is what keeps a case like this lodged in the mind. The morning did not announce itself as historic. Bonanza did not wake expecting national attention. Yet before that day was over, one home on First Avenue had become the center of a story people would return to, not because of loss, but because the silence had arrived at the end of something in motion. Hello, my friends. Welcome back to Bedtime Black Files, where life's most powerful lessons are revealed through unforgettable true crime events from around the world. If you're stepping into our community for the first time, I'm truly glad you're here. Thank you for joining us. Before we get into it, tell us where you're watching from in the comments. Consider hitting the subscribe button. Don't forget to like and share this video with someone who needs it. Your support helps our family grow, connect, and keep these powerful stories alive. Before a case becomes a headline, before court filings flatten people into lines of text, there is the life that existed before the public learned a name. That matters here. If this story is going to mean anything beyond shock, Charity has to be seen as more than the woman deputies found on a December morning in Bonanza. She has to be understood as a person whose days were once filled with the same ordinary duties, loyalties, small routines, hopes, and private concerns that shaped countless homes across the country. The violence came later. The public attention came later. First, there was a woman living a life that the people closest to her knew by heart. Public reporting identified her as Charity Beallis, age 40. Her adult son, John Powell, described her in personal terms after her death, saying she was a good Christian woman who loved her children, family, and friends more than anything, and that she always put God first. That description does more than offer grief language for television. It gives the outline of the role she held in the lives around her. Some people leave behind titles. Some leave behind status. Some leave behind arguments over how they should be remembered. Charity, in the words of the son who knew her longest, left behind a clear image of care, faith, and attachment to the people in her home. That is where her story should be approached from, if it is going to be told with any fairness at all. John matters in this section for more than one reason. He is not just the adult child left standing after the kind of loss that tears the structure out of a family. He is also the witness, in the emotional sense, to who his mother had been before outsiders stepped in. He was 24 when he spoke publicly after the deaths. In the middle of his grief, he held on to her faith, spoke about justice, and tried to protect her memory from being swallowed by procedure. In one report, he said she had fought for months to protect herself and the two younger children. In another, he made clear that his mother was not careless, passive, or absent from the struggle that was closing around her. She was trying. She was pressing forward. She was carrying more than most people looking at a headline would ever fully know. That detail changes the emotional ground beneath the case. When a surviving son speaks not in vague praise, but in the language of effort, protection, and belief, the story stops being about a tragic scene alone and becomes about a family already living under strain before the public discovery. It also tells us something about Charity's place inside the family. Mothers are often described in broad, almost automatic phrases after death. But what emerges here is more specific. She was the center of care for children who still needed daily structure. She was a point of loyalty for an adult son who, even after losing her, moved immediately into the difficult work of speaking up for her, fighting in court, and guarding what remained of her dignity. That does not happen by accident. It points to a bond built over years, not a bond invented by grief. The twins formed the emotional center of the home. Public reports did not widely identify them by name, which means responsible telling should keep the focus on their place in the family rather than turning them into spectacle. They were reported to be 6 years old, children young enough that home still defines most of the world for them. At that age, a house is not real estate. It is rhythm. It is where shoes are left, where breakfast happens, where a mother's voice directs the day, where a sibling is always close enough to matter. Twins change the atmosphere of a home in their own way. There is motion, doubling, echo, comparison, mischief, dependence, and the unspoken comfort of never facing childhood alone. Their presence would have shaped the pace of daily life, the schedule, the sounds, and the emotional weather in every room. That is why reducing this family to a case file does damage. A case file records events, dates, filings, charges, outcomes, and evidence. It has no natural place for the texture of lived family life unless someone insists on adding it back in. The children were not just victims listed beside their mother. They were part of the structure that gave her day its meaning. John was not simply a quoted relative. He was the older son carrying memories from before this marriage, before these court battles, before the nation looked over Bonanza and asked what had happened in that house. To tell the truth well, those relationships have to remain visible. The family structure also mattered in another way. It joined different stages of life under one roof and one last name. Charity had John from an earlier chapter of life. and she later married Randall Beallis in 2015, according to court records cited by People. Reports also say the couple stopped living together in February 2025. Those details look administrative at first glance, but they help explain why the household carried both maturity and vulnerability at once. An adult, son old enough to understand conflict, legal danger, and consequence, and twin children, still young enough to depend on adults for every form of safety. That kind of family structure can be rich with love, but it can also become fragile quickly when pressure enters the home. The public side of a family and the private side rarely match perfectly. From the outside, a home can appear stable because most family strain never performs itself on command for neighbors, casual friends, or passing drivers. Meals still get made. Cars still come and go. School days still begin. People still smile when spoken to. Yet inside there may already be fear, legal conflict, exhaustion, and the heavy discipline required to protect children from what they are too young to fully understand. That split between ordinary appearance and hidden distress is one of the hardest truths in cases like this. The life seen from the road is almost never the whole life being lived in the rooms. For Charity, that divide appears especially important. Reporting after her death showed a woman with public signs of faith and devotion to family, yet also a woman engaged in a hard legal fight and, according to her son, working for months to protect herself and the children. Both things can be true at once. A person can still care for dinner, homework, prayer, appointments, laundry, and bedtime, while carrying fear no guest would detect in a 15-minute visit. That is part of what makes domestic conflict so difficult for outsiders to measure. The home can keep looking familiar long after safety has started to fail. So before this story moves deeper into courtrooms, allegations, and the questions that followed December 3, hold on to the family as it was meant to be understood from the inside out. Charity at the center, John old enough to see the cost and still call his mother good, the twins young enough to fill the house with childhood, and a family life that from a distance could still pass for ordinary while distress gathered behind closed doors. That is the human ground of this case. Without it, the rest becomes noise. With it, every later development lands where it belongs, not on strangers, but on a mother, a son, and two small children whose names entered public memory only after their private world was broken. Motherhood, in a house like that, is measured in repetitions that never look dramatic while they are happening. Get the children ready. Answer the question, asked 3 times in 3 different ways. Keep track of moods, meals, school needs, socks, medicine, fears, laughter, and the 1,000 tiny repairs that hold a day together. It is easy for outsiders to notice catastrophe, because catastrophe announces itself. It is harder to notice the patient labor that came before it. Yet that labor is what family memory is built from. When John spoke about his mother with gratitude and conviction, he was not reacting only to the horror of how she died. He was speaking from a longer history in which she had already established what she meant to the people who loved her. There is also a quiet ache in the age difference. Inside this family, John had reached adulthood. The twins were still at the point where 6 years can feel like a whole lifetime. He could speak to reporters, stand in court, and carry sentences that the children never got the chance to form. They could not explain their home to the public, so the public is left to understand them through the roles they held. Young children at the center of their mother's protective life, little siblings in the eyes of a grieving older brother, and the youngest members of a family that had already entered a season of conflict before the country learned their address. That contrast, one child grown enough to testify to love, two still small enough to be known mainly through the care they received, gives this family its particular heartbreak. That is why this section has to stay close to the human scale of the story. Before law, before rumor, before argument, there was a mother trying to hold a family together, an older son watching and remembering, and two children whose lives were still supposed to be opening, not ending. Yet, a family can look intact long after it has stopped feeling safe from the inside. What changed in 2025 was not one loud public collapse that everyone could see at once. It was a chain of events that gave shape to what Charity had already begun to understand in private. The marriage she was living in could no longer be treated as a place of security. By the time the public learned her name, the legal record had already captured the outline of a home moving apart. According to reporting based on court records, Charity and Randall Beallis married in 2015 and stopped living together in February 2025. That date matters because it marks the point where separation became more than emotional distance. It became a documented fact. A line had been crossed from staying together under strain to living separately under pressure. Separation is often described in calm language, as if it were only administrative. One person leaves, another stays. Dresses change, papers follow later. But inside a family, separation can carry fear, urgency, calculation, and the heavy question of what comes next for the children. It can also reveal which conflicts are temporary and which have already reached a point where ordinary repair no longer feels possible. That is the frame this case demands. Charity was not moving through a casual marital slowdown. Public reporting shows that the break in shared living came in the same year that court filings and criminal allegations would soon place the family under harsher light. The home was no longer one unit. It was becoming a legal and emotional battleground with children at its center. That shift is important because homes do not become contested overnight in any meaningful human sense. Before a courthouse assigns a case number, someone has already spent weeks or months measuring risk, deciding what can be endured, and asking whether staying close is more dangerous than pulling away. In this story, February stands as the first clear turn in the public timeline. The marriage that had begun in 2015 was now split in practice. Whatever had once held the family under one roof no longer held. The public would only see the later filings, the hearing dates, and the aftermath. Charity had to live the earlier reality first. She had to carry the daily consequences of a marriage no longer functioning as a shared life, while still being the mother at the center of a house with young children depending on her. On March 5th, 2025, Charity filed for divorce. Reporting from People, based on court records, places that filing less than a month after the couple stopped living together. That short span tells its own story. This was not a distant separation, left to drift without direction. The move from living apart in February to filing in March suggests intention, urgency, and a decision to bring private conflict into formal process. Divorce papers do not heal a family. They do, however, declare that the old structure is no longer trusted to hold. Once filed, the dispute enters a world of hearings, custody requests, motions, and official language that can sound cold, even when the lives inside it are burning with stress. The custody stakes were immediate. People reported that Charity asked for full custody of the twins and requested a protective order for herself and the children. That detail is central to understanding what changed in 2025, because it shows that the marriage had moved far beyond disagreement over compatibility, money, or ordinary resentment. A request for full custody is not merely about where children will sleep on certain nights. It is about who is trusted, who is feared, and what kind of environment a parent believes the children need to survive and develop without harm. When that request is joined to a plea for legal protection, the emotional pressure inside the case becomes unmistakable. Charity was not only trying to end a marriage, she was trying to create space, authority, and boundaries backed by law. This is the point where the story stops being a sad headline in waiting and starts moving with force. Court records, as described by reporting, show that Randall had been arrested and charged in connection with domestic violence allegations. Later coverage also notes that online criminal court documents alleged he choked and physically harmed Charity on February 16, 2025. By October, he pleaded guilty to third-degree battery, received a suspended sentence, and was ordered to have no contact with his estranged wife or her family unless a valid court order allowed it. Those facts belong to the public record, but more than that, they explain the atmosphere in which the divorce moved forward. This was not a polite, legal uncoupling. It was a fight unfolding under the pressure of alleged violence, criminal charges, and the question of who would control access to the children. For viewers, the emotional meaning of this stage is easy to miss if it is told too quickly. Legal documents can make danger sound technical. They compress panic into filings and fear into stamped pages. Yet every request Charity made carried a personal reality behind it. Full custody meant she believed the children needed stronger protection. A protective order meant she believed legal distance was necessary. Moving out meant shared domestic life had already become intolerable or unsafe enough to break apart. None of that makes sense as overreaction when placed beside the rest of the 2025 timeline. It reads instead as a pattern of effort: step away, file, ask the court to recognize the risk, try to put formal barriers between the children and the conflict closing in around them. Distance can reduce contact, but it does not always reduce danger. That is one of the harsh lessons sitting beneath this case. Charity appears to have understood that leaving the shared home arrangement and filing for divorce were necessary steps. Her son, John Powell, later told local media that his mother fought for 9 months to save her life and the lives of the 2 younger children. Whether read as grief, accusation, or plain testimony from someone who watched the year unfold, that statement gives emotional shape to the period between separation and the final hearing. It suggests a long struggle rather than a sudden crisis. It places effort at the center of Charity's final year, not passivity. She was trying to create distance. She was trying to protect the children. She was trying to use the systems available to her before the public ever saw the ending. That is what changed in 2025 more than anything else. The private strain became a documented campaign for separation, custody, and protection. The family that once existed under one marital structure was now divided by legal claims and safety concerns. The children were no longer simply being raised inside one household. They were becoming the center of a custody fight. Charity was no longer simply enduring marital conflict. She was taking action to limit contact and define authority. Randall was no longer only a spouse in a failing marriage. He was also the opposing party in a divorce and the subject of criminal proceedings tied to allegations of violence. Each of those changes intensified the pressure on the others. Together, they turned family trouble into danger in motion. There is another reason this stage matters so much to the logic of the story. When an audience first hears that a mother and her children were found dead one day after a final divorce hearing, the timeline can seem abrupt, almost unbelievable in its speed. But speed was only the surface. Underneath was a year already moving towards separation, formal filings, custody conflict, and legal efforts to create boundaries. The hearing in December did not appear from nowhere. It stood at the far end of decisions already made in February and March. Decisions Charity had pursued while still carrying motherhood, fear, and the work of daily life. The later discovery becomes even harder to absorb once this is clear, because it was preceded by motion, warning, and a visible attempt to get free before the process reached its end. Pressure of this kind does not stay in the courtroom. It follows people into kitchens, school routines, phone calls, bedtime decisions, and the ordinary hours when children need stability even as adults are trying to build it out of damage. That is why custody conflict cannot be treated as a side issue here. For Charity, the children were not separate from the marriage crisis. They were the reason the crisis carried such weight. The calculation changes when young children are inside the same field of risk. At that point, every hearing date, every filing, every request for protection becomes part of a larger effort to keep daily life from collapsing under pressure. That helps explain the urgency visible in the 2025 record. Charity was not merely exiting a relationship. She was trying to secure a future in which the twins could live at a safer distance from the conflict surrounding the adults. There is a painful irony in that effort. The law can recognize danger in pieces. A filing here, a charge there, a hearing scheduled, a no-contact order entered. Human beings experience it as one continuous burden. They wake inside it. They parent inside it. They wait through it. By the time December arrived, the paperwork had accumulated, but so had the strain. The marriage had changed form. The family had changed form. What remained was the unresolved question at the center of so many domestic conflict cases, whether formal steps towards safety would be enough before the situation reached its worst point. So if Section 2 asked who Charity was before the headlines, this section answers what altered the ground beneath her life in 2025. She separated from Randall. She filed for divorce on March 5th. She asked for full custody. She sought a protective order for herself and the children. Her adult son would later say she fought for months to save them. The effect of those facts is cumulative. They show a mother trying not merely to leave a marriage, but to put legal and physical distance between her children and a conflict she appears to have taken seriously. That is why the story now changes temperature. Every formal step she took suggests she knew delay could carry its cost. We are no longer looking at a family only in retrospect. We are watching a chain of choices made under pressure, each one pointing toward a future Charity was trying to secure before time ran out. February 16th, 2025 sits at the center of this story for a reason that is impossible to treat as minor. Public reporting based on court and jail records says that this was the date on which Charity Beallis reported a violent domestic incident involving her husband, Randall Beallis. According to those reports, the criminal case alleged that he choked her and caused physical harm. That allegation matters not because it proves every later fear by itself, but because it placed a specific form of violence into the official record months before the deaths in Bonanza. Once that kind of allegation appears in a domestic case, the story changes. The conflict is no longer only about a failing marriage or a bitter separation or a custody dispute growing more tense. It becomes a question of danger, documented early enough that people can later look back and ask whether the warning was already plain. This point has to be handled carefully. Responsible storytelling cannot turn allegations into verdict, and it cannot pretend that a charge automatically answers every future question. At the same time, it would be dishonest to treat the February accusation as a side note. The reason it stands out is it was concrete. Reporting did not describe vague marital unhappiness or mutual shouting abstractly. It described a criminal case in which court documents alleged choking and physical harm on a specific date, February 16th, 2025. That level of detail is what gives the event its weight. It moved the crisis from the private language of a troubled relationship into the public language of law, injury, and risk. The emotional force of that detail is not hard to understand. A couple can be unhappy for many reasons. A separation can be painful without becoming lethal. A divorce can turn harsh without crossing into criminal violence. But once alleged choking enters the record, the audience is no longer looking at ordinary collapse. They are looking at a form of conduct widely treated by advocates, medical researchers, and investigators as one of the most serious danger signs in intimate partner abuse. That is why February should have mattered so much. It was not simply one bad day in a bad year. It was an episode that, if true as alleged, carried its own message about control, fear, and the possibility of future harm. Public reporting says Randall was initially charged with aggravated assault on a family member, third-degree domestic battery, and 2 counts of third-degree endangering the welfare of a minor. Those charges show that the February event was understood as more than a private argument. They also show the law recognizing 2 different dimensions of harm at once: alleged violence against Charity and alleged exposure of children to danger. That second dimension is especially important in a story centered on a mother and 6-year-old twins. Once minors appear inside the criminal framing of a domestic case, the stakes rise immediately, because the issue is no longer limited to the adult's marriage. It reaches into the children's safety, the custody fight, and the basic question of what kind of home environment existed behind closed doors. Charges do not end a crisis, they formalize it. They tell the outside world that a line serious enough for criminal process may have been crossed. From that point forward, every later filing in the divorce takes on a sharper meaning. Charity's request for full custody and for a protective order was not floating in empty air. Reporting shows those requests appearing in the same wider period as the domestic violence charges. That matters because it helps explain why separation, custody, and protection were tied so tightly together in her actions. If a mother is asking the court not only to end a marriage, but also to give her sole authority over young children and legal protection for the household, the public should understand that, as part of one larger effort to put distance between the children and a situation she believed was dangerous. There is a painful difference between how a charge reads on paper and how it is lived in real life. On paper, it becomes a case number, a list of offenses, and a sequence of hearings. In daily life, it can mean the phone never fully leaves your hand, Every knock at the door changes your breathing. The children's schedule becomes part of a safety plan, and ordinary errands start to feel like calculations. That is one reason this section matters beyond legal detail. If the February allegations were serious enough to produce those charges, then the later story cannot honestly be framed as a bolt from the blue. The groundwork for fear had already been laid months earlier. The legal system had already been told that something serious had taken place inside this family. By October 2025, reporting says Randall pleaded guilty to third-degree battery. He received a 1-year suspended sentence and was ordered to pay fines. This is one of the hardest moments in the timeline because it exposes the distance between the original seriousness of the allegations and the later shape of the case as it ended in court. Public records cited by people describe initial charges that included aggravated assault on a family member and child endangerment counts. The eventual outcome, at least from the public reporting, was a guilty plea to a lesser battery offense. That does not erase the record of February. It does, however, change how the system formally labeled the conduct by the fall of 2025 for families living through domestic abuse. That difference can feel enormous. Outside observers often assume that a guilty plea means the system worked, because there was at least some admission, some sentence, some written consequence. But that reaction can miss the emotional truth. If the person seeking protection believed the danger was high, a reduced outcome may feel less like closure and more like a warning partially heard. John Powell later said his mother fought for 9 months to save herself and the children. Read alongside the October plea, that statement lands with painful force. It suggests a family that did not experience the legal result as enough to quiet the threat hanging over their lives. This is where a careful script has to hold 2 truths at once. The first is procedural. The public record says there was a guilty plea to third-degree battery, a suspended sentence, and fines. The second is human. Paperwork that resolves one criminal case does not automatically resolve fear, restore trust, or guarantee safety. Viewers need to understand that courtroom outcomes do not always mirror the danger a victim feels at home. That gap is one reason domestic violence cases are so hard to judge from a distance. A case may appear closed in one legal sense, while remaining open in the body, mind, and daily choices of the person who still has to live with the consequences. The no-contact order is another detail that should stop anyone listening closely. Reporting says Randall was ordered to have no contact with his estranged wife or any members of her family unless authorized by a valid court order. That condition matters because courts do not attach no-contact language for decoration. Its purpose is separation backed by law. It is a formal attempt to create breathing room and reduce direct access where conflict, fear, or prior violence has made ordinary contact unsafe. In other words, the system itself recognized that distance was necessary enough to be written into the result. That detail also helps the audience understand why the divorce and custody fight cannot be treated as routine background. If one court process is managing the end of a marriage, while another results in a no-contact order, the family is moving through overlapping systems at the same time: criminal law, family law, and child-related decision-making. That overlap creates stress by itself. It also creates opportunities for confusion, conflict, and dangerous pressure points, especially when children remain the focus of custody arguments. Even the Arkansas divorce docket reflected that appearances at depositions, court proceedings, or mediation would not count as a violation of the no-contact order. That means the law was trying to maintain distance while still allowing certain formal encounters required by the case. Distance existed, but it was not absolute. The conflict had not disappeared. It had been regulated. For someone on the outside, a no-contact order can sound reassuring. It gives the impression that a line has been drawn and that the line will hold because it is official. In practice, such orders are tools, not shields. They can help. They can document boundaries clearly. They support enforcement if violations occur. But by themselves, they do not remove obsession, anger, entitlement, control, or the possibility that a dangerous person may ignore the rule. That is why this part of the story carries such ache. The paper record shows barriers being built, separation, a divorce filing, requests for protection, criminal charges, a later plea, and no contact terms. Yet the existence of those barriers did not keep the case from ending in deaths that drew national attention. There is a reason advocates, medical workers, and researchers pay close attention when a domestic abuse case includes alleged choking or strangulation. A widely cited study, published in the Journal of Emergency Medicine, found that prior non-fatal strangulation by an intimate partner was associated with more than 6-fold higher odds of attempted homicide, and more than 7-fold higher odds of completed homicide among abused women. The researchers concluded that non-fatal strangulation is an important risk factor for homicide and should be specifically screened for when assessing abused women. That is the educational core this case forces into view. When reports say Charity alleged that Randall choked her in February, that is not merely another violent detail among many. It points to a pattern that research has long treated as one of the clearest warnings of future lethal danger. This matters beyond courtroom paperwork because strangulation is often misunderstood. People who have never studied domestic abuse may think of it only as one form of assault among others, severe but not uniquely informative. The research says otherwise. It often leaves little visible injury, while still causing serious medical harm and marking a major escalation in control. In plain language, it tells you that the abuser has placed hands around the victim's neck, cut off air or blood flow, and crossed into conduct that can kill within moments. Even when the victim survives, the event carries a message about power and about how close the violence can come to death. That is why professionals treat it with such urgency. One more point makes February impossible to dismiss. Researchers note that strangulation often leaves little outward evidence, even when the internal damage is serious. A victim may show faint marks or none at all while still suffering breathing changes, trouble swallowing, neurological symptoms, memory problems, or delayed complications. That means people who expect obvious injury can dangerously underestimate what occurred. In domestic cases, that misunderstanding can travel from family members to employers to courts to the public. It can make a survivor look less endangered precisely when the threat is high. When children are also present, the danger multiplies because they may be physically nearby, emotionally traumatized, or placed at risk by the same event that targeted the parent. So the February allegation mattered medically, legally, and emotionally at once. It was not only a claim about one assault. It was a warning that the violence inside this family may already have crossed into a level professionals treat as life-threatening. That is why risk assessment looks beyond bruises and asks, how close did death already come here? Placed inside this timeline, the February allegation becomes one of the most important facts the public has. It does not answer every unresolved question in the case, and it does not permit anyone to skip over proof or due process. What it does is show that months before December 3rd, there was already an alleged event on record that research and advocacy both recognize as a major lethality warning sign. Once that is understood, the story changes shape again. The later deaths do not look like a tragedy that appeared without signal. They look like the possible culmination of a pattern that was serious enough to produce charges, a plea, a no-contact order, and a mother's continued effort to create distance for herself and her children. This is the first place in the case where information itself starts to hurt, not because it is graphic, but because it reveals that the ending may have been preceded by a danger pattern people already knew how to read. That is why February should have changed everything. Even without overclaiming, even without naming any person as responsible for the deaths before official proof, the timeline shows enough to justify a hard conclusion. What happened in that month was not a footnote. It was one of the clearest warnings in the entire story, and its meaning reached far beyond one courtroom result. By the end of the February incident, the danger was no longer only something Charity could feel inside her own home. It had started to move outward into public view. That is what makes this stage of the story so hard to hear. A mother can sometimes sense risk long before other people believe her, but once that fear begins appearing in public, the case changes again. It becomes a record not only of what happened to her, but of what she was trying to say while she still had time to say it. Reporting from People shows that in August 2025, months before the killings, Charity commented publicly on an unrelated 5 News Facebook post and described herself as the victim, accused the system of shielding the criminal, a local doctor, and wrote that lives are at stake, including the lives of young children. That was not hindsight. That was a warning in real time. Those words matter because they were not written after tragedy, when everyone suddenly knows how to read the signs. They were written before December 3rd, while Charity was still trying to move through the system that she believed was failing her. Her comment, as quoted by People and Fox News, said she had tried to contact prosecuting attorney Daniel Shu, and that he would not even accept a letter from her. She wrote that her voice as the victim had been shut out. A statement like that does more than express frustration. It tells the public that the person inside the danger felt unheard by the very process that was supposed to help her. Even stripped of emotion, those words would be serious. Read in context. They land with the force of someone trying to make the outside world understand that her case was not under control. There is a particular kind of pain in public warnings that are clear enough to remember later, but not strong enough, in the moment, to trigger the response the victim needs. That is one reason this section deepens the tragedy so sharply. Charity did not leave behind silence. She left behind language. She named herself as the victim. She said the wrong person was being protected. She said lives were at stake. She specifically included young children in that fear. Once those statements are known, the later deaths do not feel like a horror that arrived without notice. They feel like a horror that may have been announced and not adequately answered. The public warning went beyond one comment. Fox News reported that in August she also shared screenshots from an article bearing a stark message. If a partner has ever strangled you, the risk of later murder rises dramatically. The post included hashtags calling for justice, accountability, and an end to corruption and systemic failure. That matters, because it shows that Charity was not speaking in vague emotional terms alone. She was pointing directly toward a known danger pattern and placing her own life inside that frame. She had already lived through an alleged February choking incident that had produced charges and later a plea to third-degree battery. By August, she was sharing material that connected strangulation to lethal risk. In other words, she was warning people with the same type of information professionals use to explain why certain abuse cases require urgent attention. This is where many victims become easiest to miss. They do not always produce one single perfect sentence that every outsider instantly understands. More often they speak in fragments, a comment under a news post, a reposted article, a line about being unheard, a phrase about children being in danger, a public appeal that sounds angry to people who have never had to beg a system to notice them. Charity's public words fit that pattern. They were not polished. They were not arranged for later storytelling. They were immediate, personal, and urgent. That is often how fear looks when someone is still living inside it. The message arrives in pieces because life itself is being lived in pieces. Hearings, filings, calls that go nowhere, protective steps that never feel complete, and children still needing breakfast and bedtime, while the adults fight over safety and control. Her sense that the system was not protecting her was not hidden between the lines. She wrote it directly. She said she had been treated like the problem, while the offender was being protected. She said transparency mattered, accountability mattered, victims mattered. That combination is striking because it shows both fear and clarity. She was not confused about what she believed was happening around her. She was identifying it as a failure of institutions, not simply a private dispute with one man. For an audience, that shifts the moral weight of the story. The question is no longer only what danger existed inside the marriage. It becomes what the surrounding systems heard, recorded, reduced, or failed to act on while the family was still alive. John Powell's later words sharpened that point. According to People, he said his mother fought for 9 months to save her life and the lives of the twins, and that nothing happened. His statement is painful because it sounds like the final translation of all the pieces Charity had already been putting into public view. Where her posts showed warning, his words showed the result of warning unanswered. Where her comments showed that she felt shut out, his grief suggested that the shut door never truly opened in time. Together, those voices make the timeline feel less like a chain of random events and more like a visible countdown. February put danger into the record. March put separation and custody into the record. August put fear into public language. December brought the deaths. That countdown is what gives this part of the story its power. Most people can accept tragedy more easily than preventable tragedy because preventable tragedy forces a harder question. What was already knowable before the ending arrived? In Charity's case, the public can now see that the warning signs were not buried in secrecy. Some were sitting in plain sight. She wrote that young lives were at stake. She shared information about strangulation and murder risk. She described being shut out. None of those details prove every unanswered point in the case, and they should not be stretched beyond the record. But they do establish something morally serious. This family's story contained visible signals before the final discovery in Bonanza. There is another reason her public warnings matter so much. They restore agency to a victim who might otherwise be remembered only for how her life ended. Charity was not passive in this record. She separated. She filed for divorce. She sought custody and protection. She spoke publicly. She to contact officials. She shared information she believed explained the danger she was facing. That sequence matters because it rejects one of the easiest false assumptions people make about domestic violence victims: that they said nothing, did nothing, or failed to recognize the seriousness of their own situation. The public record shows the opposite. Charity appears to have recognized the threat, named it, and tried to get others to take it seriously before the story reached its worst point. That is why this section hurts in a different way from the discovery at the house. The house gives shock. The warnings give grief with structure. They force the listener to look back over the months before December and see not only conflict, but communication. Not only fear, but attempted disclosure. Not only a mother in danger, but a mother trying to tell people that danger had already moved close to her children. Once those pieces are placed in order, the case stops feeling like random horror and starts feeling like an alarm that kept ringing in different forms until the worst finally arrived. And that is what makes the silence at the house so devastating in hindsight. By the time no one answered the door, Charity had already been answering the danger for months. What makes this section essential is not simply that Charity was afraid. It is that she left a trail the public can now read in sequence. A criminal allegation in February, a divorce in March, public cry in August, a hearing in December, a welfare check the next morning. Each point holds its weight. Together they form the shape of a warning already visible before the story became national news. On December 2nd, 2025, the conflict entered the room where private damage became official. Charity Beallis and Randall Beallis appeared for what multiple reports described as the final divorce hearing at the Sebastian County Courthouse in Fort Smith. By then, the marriage had already been broken by separation, criminal allegations, a later guilty plea to third-degree battery, and months of visible strain. A final hearing changes the pressure in a way earlier court dates do not. Before that day, the case was still moving. After that day, the shape of the family's legal future could be fixed in written orders. That is what makes the date so severe in hindsight. December 2 was not one more entry on a crowded docket. It was the day the law was preparing to decide how this fractured family would function next. The next morning, Charity and the twins were found dead. The hearing matters first because of timing, but timing alone is not enough. What happened inside that courtroom belonged to a longer fight already built across the year. Charity had filed for divorce in March. She had requested full custody and sought legal protection for herself and the children. Randall had faced domestic violence charges tied to the February incident and later pleaded guilty to third-degree battery. A no-contact order had also entered the picture, though court records reflected that appearances at depositions, court proceedings or mediation would not count as violations. All of that meant the final hearing arrived with history attached to every argument. Nobody walking into that room was starting fresh. Each side was carrying months of filings, fear, accusation, and legal positioning. The case was not cooling down as it neared conclusion. It was tightening. Custody sat at the center of that pressure. For outside observers, divorce can sound like a dispute over adults separating their lives, property, and routines. In reality, children change the stakes completely. Custody is where fear becomes specific. It asks where the children will live, who will make daily decisions, how access will be structured, and what level of trust the court is willing to place in each parent. In this case, reporting indicates Charity had sought sole custody, while later reporting also said Randall was awarded joint custody at the December 2 hearing. That contrast matters, because it shows how much was resting on the outcome. Charity had spent months trying to create distance and protection. The hearing appears to have produced a result that did not give her the sole authority she had asked for. That alone is enough to explain why the atmosphere around that date was so charged. The emotional force of custody conflict is often hidden behind calm legal phrases. Joint custody can sound balanced on paper. Sole custody can sound severe to people who do not know the facts. But inside a family already marked by domestic violence allegations, those terms carry fear, urgency, and competing visions of safety. Charity was not fighting over abstract parental status. She was fighting over the lives of 2 6-year-old children who still depended on adults to define every safe boundary around them. When a mother requests full custody after reporting violence and later sees the legal process moving towards shared parental authority, the issue is no longer simply whether the marriage is ending. The issue becomes whether the protective distance she has been trying to build will be enough once the court sets the terms. That is why December 2 feels like a cliff edge in this story. The hearing did not happen in isolation from February or from the public warnings Charity posted in August. It happened after all of that. It happened after the alleged choking incident had entered the record. It happened after she described herself publicly as the victim and wrote that young lives were at stake. It happened after months in which, according to her son John Powell, she fought to save herself and the twins. Put those details together, and the hearing stops looking like a routine final step. It becomes the point where legal process and personal fear were forced into the same room and asked to produce an answer. That is what gives this section its pressure. The audience already knows the next morning ends in a welfare check. The question is what the courtroom did, and did not, resolve before that morning came. Pause here for a second. Think about how cases like this hold attention. They do not stay with people only because of violence. They stay because of the moment when everyone can feel the danger narrowing and still hopes the system will hold. If you value careful, true crime storytelling that follows the warning signs, not just the headlines, subscribe to Bedtime Black Files. Leave a like and tell me in the comments what worries you more in a case like this. A final custody hearing after months of conflict, or the fact that the next morning gave no one time to adjust to the ruling. Your response helps keep these stories visible and helps this community grow around real conversations, not empty noise. The attention point here is immediate. A final divorce hearing took place on December 3rd, and the bodies were found on December 3rd. The related point is just as strong. Many people know the feeling of entering a meeting, office, or courtroom, believing that one ruling may alter the entire future of a family. The engaging point is the conflict itself: custody, protection, and legal authority were all being decided in the shadow of a domestic violence case and public warnings that lives were at stake. The ask point, the reason this timeline becomes so hard to leave, is simple and painful. If the hearing marked the end of the legal battle, why did the family reach the next morning in even greater danger? That question sits over every fact that follows. The significance of the decree not yet being finalized deepens the pressure further. THV 11 reported on December 4th that there were no documents publicly available referencing the final hearing or its outcome. Later reporting from KBTX and other outlets described John Powell going to court to intervene and set aside the dismissal of the divorce case so that the divorce could be finalized posthumously. In plain terms, the hearing had happened, but the paperwork had not yet fully matured into a completed final decree before Charity died. That gap may sound technical, but it matters enormously. In family law, a hearing can indicate what the court decided, while the decree is the formal written instrument that makes the divorce complete and enforceable in the record. Without it, a case can enter a strange legal space where a marriage has been heard to conclusion, but not fully reduced to final paper. That in-between status gave the aftermath an added cruelty. On December 4th, an attorney for Randall filed a motion to dismiss the divorce case because Charity had died. John Powell then sought to intervene, arguing that the divorce had effectively been granted on December 2 and should be finalized rather than erased by dismissal. He was not only grieving his mother and the twins, he was also trying to preserve the legal meaning of the day before they were killed. That fight would later spill into disputes over burial, probate, and what the law should treat as finished. The unfinished decree therefore matters for more than legal trivia. It shows that even after the hearing, nothing in this family had truly settled. The last stage had been reached, but the final paper had not yet caught up. The law was still mid-sentence when death interrupted it. This detail also sharpens the suspense of the timeline. A final hearing suggests arrival. An unsigned or not yet entered decree suggests delay. That combination is hard enough in ordinary divorces. In this case, it becomes devastating. The family reached the threshold of legal conclusion, but not the clean completion people expect when they hear the phrase final hearing. Instead, the record shows a hearing one day, deaths the next, and legal confusion immediately after. The audience can feel how narrow that gap was. Charity was close enough to the end of the marriage to stand in court for its final hearing, yet not far enough from it for the legal separation to become fully secure on paper before everything stopped. Legal tension at this stage was different from the tension of February or March. Earlier in the year, there was still room for uncertainty about where the case might go. By December 2000, uncertainty had narrowed into consequence. Lawyers were no longer dealing only with allegations, requests, and interim positions. They were confronting the question of what arrangement would govern the children and what legal shape the separation would finally take. That is why the hearing works as a true cliff edge. It gathered every unresolved issue into one place: the marriage, the children, the claims of danger, the boundaries already attempted, and the court's power to define what happened next. When a case reaches that point, emotions do not calm simply because everyone is dressed for court. They often rise because the end of the process can feel like the beginning of permanent loss for one side and permanent exposure for the other, for the family involved. So the real pressure of December 2 lies in 4 facts, sitting tightly together. First, the final divorce hearing took place that day in Fort Smith. Second, Custody remained central, with reporting indicating Charity had sought sole custody and Randall was awarded joint custody. Third, the hearing came after months of domestic conflict, criminal process, and public warning, making it the legal climax of a year already marked by fear. Fourth, the decree was reportedly not yet finalized in the record before Charity died, leaving the case suspended between decision and completion. Taken together, those facts turn the date into more than background. They make it the last formal moment before the story crosses from legal battle into homicide investigation. The courtroom came first. The unanswered house came next. And in that one-day gap, the timeline became almost unbearable to contemplate. December 2 had ended without closure. The hearing was over, the issues had been argued, and the future of the family had been pushed to the edge of official decision. Yet the written finality Charity had been fighting toward was still not secure on paper. That unresolved tension carried into the next morning. On Wednesday, December 3rd, 2025, at about 9:30 a.m., deputies with the Sebastian County Sheriff's Office were sent to a home on the 1100 block of First Avenue in Bonanza for a welfare check, even before anyone knew what waited inside. The shape of the day had already changed. A welfare check means someone could not be reached. Someone was worried enough to ask for law enforcement, and a house that should have answered had gone silent at the worst possible time. That opening detail matters, because it preserves the sequence exactly as it entered the public record. This did not begin with a dramatic chase, a frantic confession, or authorities arriving after a known shooting report. It began with uncertainty. Deputies came to check on a family. The first question was who had done what. The first question was why no one was answering at all. That kind of uncertainty changes the emotional texture of a scene. It means the people outside the home were still standing in the last narrow space where relief was possible. A delayed answer can have an ordinary explanation. A missed call can be harmless. A locked door can mean nothing more than timing. For a few moments, every less terrible possibility was still available. No one answered the door at first. That detail was reported both by people, citing the sheriff's office release, and by local coverage following the case. The silence at the door is one of the reasons this moment has stayed lodged in public memory. Homes usually answer in some way. A voice calls out, steps cross the floor. Someone opens with irritation, confusion, or apology. Here, there was no answer from inside. Two workers at the property eventually helped law enforcement get in. That small practical fact gives the scene its human shape. Officers were not walking into a clearly declared crime scene. They were being let into a home that had stopped responding, still moving through the mechanics of a welfare check. Not yet the full horror that would follow once the threshold was crossed. Inside, deputies found 3 bodies. The woman was identified as 40-year-old Charity Beallis. The children found with her were her twin 6-year-olds, though many reports initially avoided publishing their names. Authorities said all 3 had gunshot wounds. In that instant, the uncertainty that brought officers to the property disappeared, and a homicide investigation began. The sequence is devastating, partly because of how quickly it turns. One moment, law enforcement is trying to make contact during a welfare check. Next, a mother and 2 children are dead inside their home. Public reporting has repeated those core facts consistently. Deputies entered after getting no answer, found Charity and the children inside, and observed gunshot wounds on all 3. By this point in the story, the emotional meaning of that discovery lands harder than it did in the opening hook, because the audience now knows what stood behind it. This was not an isolated household, suddenly overtaken by inexplicable violence. It was a home already marked by separation, criminal allegations, custody conflict, public warnings, and a final divorce hearing held the day before. The bodies were found on December 3rd, but the pressure surrounding them belonged to the whole year. That is why the discovery scene has such force. Does not arrive as random chaos. It arrives as the collapse of a family already living beneath visible strain, with children still at the center of every legal and emotional question. The gunshot wound reporting shaped the first public understanding of the case. The sheriff's office said the 3 victims were found with gunshot wounds, and autopsies would be conducted to determine the official causes and manners of death. That distinction matters. In the earliest hours of a case like this, law enforcement often releases only the facts they can safely confirm. Gunshot wounds tell the public the deaths were violent. Autopsies tell the public that the full medical and forensic process is still underway. Early reporting, therefore, carried 2 realities at once. The nature of the deaths was already deeply alarming, but the official process of explanation had only just begun. That mix of certainty and uncertainty drove much of the public reaction in the first days. Search warrants were quickly written and executed, according to the sheriff's office statement, quoted by People. Interviews had already taken place, with more expected. Officials also said additional information was still being gathered. Those details are important because they show how fast the case moved from discovery to active evidence collection. Once the bodies were found, the house was no longer simply the site of an unanswered welfare check. It became a place to be processed for physical evidence, digital leads, witness statements, timelines, and every material trace that might explain how a mother and her children ended up dead less than a day after a final divorce hearing. Yet at the same time, authorities did not publicly identify a suspect or announce an arrest in those early reports. That gap fed the first wave of public disbelief and speculation. Initial public reaction formed around the same 2 facts that continue to define the case. A mother and her twins were found shot to death in their home, and it happened one day after the final divorce hearing. National coverage emphasized that sequence because it was impossible to ignore. Local reporting added the texture of the place, giving Bonanza, South First Avenue, and the home itself a sharper presence in the public mind. The response was immediate because the timeline sounded less like an ordinary local homicide story and more like a catastrophe that had walked straight out of a legal fight still unfolding in court records. Even before anyone had full investigative answers, people could already see the outline of a question that would not go away. What had happened between the hearing and the welfare check? That question was made heavier by the age of the children. Reports said they were born in 2019 and were believed to be about 6 years old. At that age, public sympathy moves almost instantly from concern to heartbreak. The case was no longer only about marital conflict or legal process. It was about 2 very young children whose lives had been folded into adult danger and brought to a violent end inside their own home. This is part of why the story spread beyond local interest so quickly. Cases involving children always carry a different emotional charge. But here the charge was intensified by the known context: prior domestic violence allegations, a custody battle, and a hearing the day before. The children did not appear in the story from a distant background. They were central from the first confirmed report. For the family, the discovery did not arrive as a headline. It arrived as disbelief too large to process all at once. Local television quoted relatives trying to put language around the shock. Charity's son, John Powell, described a rush of emotion so intense it moved from anger to sadness to tears in rapid succession. He also said his mother would have fought for the children. Those remarks matter because they show what public reaction looks like when it comes from the inside of loss, instead of the outside of curiosity. John was not responding to a true crime story. He was responding to the destruction of his family, while still trying to defend his mother's strength and explain a pain that did not fit inside a single mood. His words also deepen the meaning of the welfare check itself. To the public, a welfare check can sound procedural. To a family member, it becomes the dividing line between the last hours of uncertainty and the moment life is torn apart permanently. Before deputies entered, loved ones still had room, however small, to hope that no one was answering for some ordinary reason. Once deputies were inside, there was no longer any such room. The feared outcome had arrived in its fullest form. A mother was gone. The twins were gone. The house that had failed to answer now had an answer nobody could bear. That is what gives this section its emotional weight. It is not only the violence of the discovery, it is the way the discovery closes the final door on hope. Early uncertainty remained in another sense as well. Authorities were collecting evidence, waiting on autopsy results, and continuing interviews publicly. There was still no announced arrest. Local reports stated that everyone investigators had spoken with was cooperating, and one report said that, as of that Friday, Charity's husband was not a suspect. Those details do not reduce the shock of the scene. They explain why the aftermath immediately became a tangle of grief, suspicion, questions, and procedural caution. The public knew enough to understand the scale of the tragedy, but not enough to close the story into certainty. That combination often keeps a case alive in the public mind long after the first reports fade, because the emotional verdict arrives before the legal one does. Chronologically, December 3 is simple. Deputies were called for a welfare check at about 9:30 that morning. No one answered. 2 workers helped officers get inside. Charity and the twins were found dead with gunshot wounds. Search warrants followed. Interviews began. The crime lab and medical examiner became part of the process. But emotionally, the date is anything but simple. It is the point where every warning sign described in the earlier chapters crashes into physical reality. The February allegation, the custody fight, the public posts, the hearing on December 6th, and the unresolved decree all now stand behind one house in Bonanza and one devastating morning. That is why the welfare check became more than a police response. It became the moment the whole story broke open, in a way no one who loved Charity or the children could ever undo. The first reports also carried a terrible visual contradiction that made the case even harder for people to absorb. The home was described in national and local coverage as large, stately, even impressive from the outside. Yet inside that same house, deputies found the final proof that appearance had nothing to do with safety. That contrast helped shape the public conversation. In the earliest days, people were not only reacting to a triple homicide. They were reacting to the collapse of a place that, from the outside, still looked stable, successful, and removed from immediate catastrophe. In true crime stories, audiences often search for some visible signal that disaster was approaching. Bonanza offered no such comfort. The address, the house, the daylight, and the routine language of a welfare check all suggested normal life, right up until the moment law enforcement crossed the threshold and found evidence of violent death. That is part of why the shock traveled so fast. It forced everyone following the case to confront the same hard truth. Homes do not announce their danger to the street, and by the time the outside world learns the truth, the people inside may already have run out of time. The public could only watch the known facts arrive one after another and realize that the silence at the door had been the final warning anybody received. That is how an unanswered door became the first public sign of catastrophe, already complete inside. The morning of December 3 ended the uncertainty of the welfare check, but it did not end the uncertainty itself. It merely changed its form. Once Charity Beallis and her twins were found dead inside the Bonanza home, the case moved out of the first shock of discovery and into the slow, exacting work that follows every major homicide investigation. Secure the scene, separate what is known from what is assumed, document every room, seize what might matter later, identify who needs to be interviewed, and begin building a timeline strong enough to survive scrutiny. This is the stage where grief starts demanding answers and law enforcement often responds with caution, because a rushed mistake at the beginning of a homicide case can distort everything that comes after. In Bonanza, that next phase began under the direction of the Sebastian County Sheriff's Office, with the Arkansas State Police also identified as a lead investigative partner in later reporting. Sebastian County's role remained central because this was, at its core, a local homicide investigation born inside one home in its jurisdiction. The sheriff's office had handled the welfare check, entered the residence, and made the first public confirmation that Charity and the children had been found dead with gunshot wounds. From there, local investigators had to do more than preserve the scene. They had to determine what evidence needed to be collected immediately, what witness accounts might fade if not captured quickly, and how to move forward in a case that had already drawn intense attention because of the divorce hearing held the day before. Local investigators in cases like this become custodians of both evidence and expectation. Every family member wants speed. Every reporter wants clarity. Every resident wants reassurance. Yet investigators can only say what they are prepared to prove. That tension shaped this case from the start. Search warrants were one of the first visible signs that the investigation had moved into full procedural mode. KTV reported on December 18th that law enforcement, led by Arkansas State Police and the Sebastian County Sheriff's Office, had begun the investigation and were in the process of serving search warrants, while no suspect had yet been identified publicly. That detail is important because search warrants do not mean police already have a final theory. They mean investigators have persuaded a judge that certain places, devices, records, or materials may hold evidence relevant to the deaths. In a case like this, warrants can involve the home itself, phones, computers, digital accounts, vehicles, medical information, financial records, surveillance footage, firearms evidence, and any other source that might help establish movement, communication, timing, motive, and opportunity. The public rarely sees the contents right away, but the very fact that warrants were being served showed that investigators were following the evidence outward from the house, not standing still inside the first scene. Interviews were moving at the same time. Early reporting said law enforcement had already interviewed several people and expected to speak with more. That sounds simple when read in a short article, but interviews are often where a case either gains structure or sinks into contradiction. Investigators have to speak to family, neighbors, friends, attorneys, court-connected figures, anyone who saw or spoke with Charity, and anyone who may know what happened between the December 2 hearing and the December 3 welfare check. They also have to compare those accounts against physical and digital evidence instead of trusting memory alone. In emotionally charged cases, interviews are not merely about collecting stories. They are about testing them. People misremember times. Grief compresses sequence. Fear changes what witnesses are willing to say. Strong investigators do not only ask what happened, they ask what can be verified, what can be disproved, and what detail may matter later, even if it sounds small in the first week. That helps explain why official information often narrows once a case begins receiving broad attention. To the public, silence can feel suspicious. To investigators, silence can be a way of protecting the case from contamination, rumor, and premature conclusions. The challenge in Bonanza was that the known context already made the deaths feel connected to a broader pattern. The February domestic to violence case, the August public warnings, the final divorce hearing, and the discovery of the bodies one day later. The public did not need many facts to understand why the story felt urgent. Investigators, however, still had to establish sequence with discipline. They could not simply inherit the public's narrative and call it proof. That gap between what people suspected and what detectives could responsibly confirm became one of the defining pressures of the investigation. By December 9th, federal involvement had become part of the conversation. A 5 News report said federal law enforcement was now assisting the investigation into the deaths. Another 5 news items stated that the Department of Homeland Security investigations and the U.S. Secret Service were assisting local authorities. Those details surprised many observers, but they are less unusual than they sound. Federal agencies do not need to take over a local homicide case in order to help with specialized work. They may assist with digital extraction, intelligence support, financial tracing, communications analysis, interstate leads, technical forensics, and coordination across jurisdictions. The local agency can remain in charge, while federal partners contribute tools the local team either does not have at scale or would prefer to supplement because of the case's complexity. The FBI's own public material helps explain why such support appears in violent crime investigations. The Bureau states that it can provide law enforcement assistance to other agencies, including evidence response teams, laboratory expertise, behavioral analysis, and digital forensics when requested. In a separate FBI explainer on a mass killing investigation led by local police, the Bureau said it provided assistance, but was not running an independent or parallel investigation. Instead, it deployed evidence response personnel, laboratory experts, interview support, computer examination help, and behavioral analysis consultation at the local agency's request. The FBI laboratory also says it may assist partner agencies with forensic examinations they do not offer themselves, while the regional computer forensics laboratories program exists specifically to extract and analyze digital evidence from devices in support of federal, state, and local investigations. In plain language, federal help can appear because modern homicide cases often depend on phones, cloud accounts, deleted data, location records, image analysis, and other technical evidence that requires specialized capacity. That matters here because Bonanza was never only a physical scene investigation. Once the house was processed, the real shape of the case likely extended into messages, call logs, calendars, court communications, device activity, online accounts, and any digital trace that could narrow the time between the hearing and the killings. A phone can reveal movement, contact, or silence. A car system can preserve location history. A cloud account can show whether photos were taken, files were deleted, or devices were synced. Digital evidence is now part of how investigators rebuild the hours no witness directly saw. It can confirm a statement, expose a lie, or show that a timeline everyone assumed was correct needs to be rebuilt from the ground up. That is one reason federal digital or forensic help can be especially valuable, even when the deaths themselves happened entirely within one county. For the public, however, specialized assistance did not solve the most painful problem. There were still very few answers. Reporting through mid-December continued to say that no suspect had been publicly identified and no one had been charged. KTV reported that search warrants were being served, but no suspect had yet been identified. CNN affiliate reporting carried by KBTX likewise said no suspects had been publicly named and no one had been charged, while John Powell said that uncertainty left him fearful for his own life and for others' safety. That combination created a specific kind of frustration. The public could see motion inside the investigation. Warrants, interviews, multiple agencies, forensic work, yet the central question remained open. People did not want procedural signs alone. They wanted to know who was responsible, whether anyone was in danger, and why the case still seemed suspended between movement and silence. 1 month later, that frustration had not gone away. 5 News reported in January 2026 that the community was still seeking answers. That phrase captures the emotional reality of this investigative stage better than any technical summary could. Communities do not experience homicide investigations as case management exercises. They experience them as waiting. Waiting for an arrest. Waiting for a name. Waiting for enough explanation to make daily life feel less exposed. Bonanza. The waiting was sharpened by the fact that the victims were a mother and 2 small children, found one day after a final divorce hearing that had already drawn public attention. Every day, without a public answer, widened the space into which rumor, fear, and private theories could spread. That is often what limited official comment produces, even when the restraint is understandable from an investigative standpoint. So, this section changes the story's suspense without reducing it. The horror of December 3rd gave the case its first blow. The investigation replaced that immediate shock with a different pressure. Search warrants being served, interviews unfolding, state and local agencies working together, federal partners joining in, and still no public suspect named. That is not inactivity. It is the hidden labor of a homicide case, trying to become legally durable. Yet to a grieving family and an anxious public, careful work can feel almost indistinguishable from delay. That is why the investigation expands the story instead of cooling it down. Every new procedural step proves that law enforcement understands the seriousness of what happened in Bonanza. Every unanswered question proves that understanding seriousness is not the same as solving the case quickly. The house on First Avenue had already given up the first truth. What followed was the longer struggle to see whether the rest of the truth could be pulled out of records, devices, interviews, and physical evidence before fear outpaced patience. There is an important distinction hidden inside that frustration. No suspect publicly identified does not mean investigators have no direction. It can mean they are protecting witness accounts, waiting on forensic returns, comparing digital evidence before making an accusation, or trying to avoid giving a potential offender a map of what law enforcement already knows. Public impatience is human. Families want the story to stop hovering over them. But homicide cases are not solved by emotion alone. They are solved by evidence that can hold up in court. Search warrants must be supported. Devices must be preserved correctly. Interviews have to be compared for consistency. Timelines have to be tested against records, not only repeated because they sound persuasive. The more public attention a case receives, the more dangerous a weak, early accusation becomes. If charges come too soon and collapse later, the damage to justice can be permanent. That does not make the waiting easier. It explains why investigators often move in ways that look slow from the outside, while being intensely active underneath. The case also carried a second layer of tension, because the legal aftermath was unfolding at the same time as the homicide work. While investigators were serving warrants and conducting interviews, the family was already battling over the divorce's status, burial rights, and the meaning of the December 2 hearing. Katie reported that the bodies would be released separately, with Charity's body going to her adult son for burial and the twins' bodies to their father, while the court said it lacked jurisdiction to rule on the divorce motions. That overlap matters because it meant the public was watching two systems at once, one trying to determine what happened in the house, another trying to sort out what death had interrupted in the courtroom. When people feel they are receiving only fragments from both processes, frustration grows faster. They do not only want an arrest, they want a coherent explanation for how a family could be in court one day and in the morgue the next. The unanswered space, therefore, became part of the story itself. Bonanza was no longer waiting only on forensic answers. It was waiting on reassurance that warning signs, official action, and investigative effort might still converge into accountability. Until that happened, every warrant, every interview, and every agency update carried two meanings at once: progress for the case file and proof for the public that the answer was still out of reach. By this point in the story, the emotional pressure is strong enough to tempt people into treating the most obvious suspicion as if it were already proven. That is exactly where careful storytelling matters most. A responsible account has to stop and separate what is documented from what is merely assumed, no matter how charged the timeline feels. The documented facts are serious enough on their own. Charity Beallis and her twin children were found dead with gunshot wounds inside their Bonanza home on December 3, 2025, after deputies responded to a welfare check. The day before, Charity and Randall Beallis had attended a final divorce hearing in Sebastian County. Earlier in 2025, Charity had reported a violent domestic incident. Randall had been charged, and public reporting later said he pleaded guilty to third-degree battery and was ordered to have no contact with Charity or her family, except as allowed by court order. Charity also made public statements in August, saying she was the victim, that lives were at stake, and that young children were in danger. Those facts are documented through court records and reporting. They are enough to explain why the case drew intense attention without adding anything invented. Just as important are the things public reporting had not established. KTV reported on December 9th that no suspect had been identified at that time. KTV reported again on December 18th that investigators were serving search warrants and had not yet identified a suspect in the killings. Other coverage, including KBTX and later People, said no one had been charged publicly in the deaths and that authorities had not confirmed whether Randall Beallis was a suspect. That line matters. It means the public could see a troubling pattern and still not possess an official answer. It means a responsible narrator cannot take a name that appears central to the timeline and present that person as legally or factually confirmed to have committed the murders when the reporting had not reached that conclusion. Suspicion may exist in the minds of viewers, family members, or the wider public. Suspicion is not the same thing as proof, an arrest, a charge, or a conviction. If a story blurs those categories, it stops being careful and starts becoming reckless. This distinction is not a weakness in the script. It is a sign of discipline. Many storytellers damage their own credibility by moving too fast from this. Looks likely to this is what happened. That kind of leap may satisfy a desire for certainty, but it leaves the audience standing on ground that can collapse later. Investigations change. New evidence appears. Forensic results narrow or redirect theories. Witness statements are corrected. Digital records surface. Prosecutors decide whether available evidence can support charges. A narrator who outruns that process does not look bold. That narrator looks careless. In a case involving a dead mother, 2 dead children, and a living person not publicly charged in the killings, words carry legal and moral weight. Accuracy is not just a technical standard here. It is part of basic fairness. That is why allegations must remain allegations. Charity's February report matters. The charges matter. The later plea matters. The no contact order matters. Her August warnings matter. The final hearing on December 2 matters. The welfare check and the discovery on December 3 matter. All of that can be stated clearly because all of it is anchored in reporting and court records. What cannot be stated as fact is a claim the public record had not yet proven. A true crime script gains authority when it shows the audience that it knows where the line is and refuses to cross it for effect. The goal is not to drain the story of force. The goal is to keep the force connected to what can actually be supported. That matters even more in a case like this, because the known facts already create powerful tension. A mother reported violence. She sought protection. She warned publicly that lives were at stake. She went to a final divorce hearing. The next morning, she and her children were found shot to death. Nothing about that sequence needs embellishment. The timeline itself carries the weight. Once a script starts pushing beyond that record, it risks weakening the very thing that makes the case compelling. The audience can trust that every serious point being made rests on something real. Trust is hard to earn and easy to lose. A channel built on real cases cannot afford to trade reliability for a stronger sounding sentence. There is also a deeper reason to hold this line. Defamation is not only a legal concern, it is a storytelling failure. When a narrator states or strongly implies a fact that a specific living person committed a crime without official proof, the story stops serving truth and starts serving certainty for its own sake. That hurts everyone. It can harm the investigation. By muddying public understanding, it can expose a channel to justified criticism. It can also reduce the victim's story to a vehicle for accusation, instead of keeping the focus where it belongs, on the warning signs the system's response, the unanswered questions, and the need for accountability grounded in evidence. The strongest way to preserve tension is to be precise. Say what is known. Say what had not been established publicly. Say why the difference matters. Let the audience feel the discomfort of that gap, rather than trying to close it with guesswork. In this case, the gap is powerful on its own. There was a documented history of domestic conflict. There were public warnings. There was a final hearing. There was a welfare check one day later. There was an ongoing investigation with search warrants, interviews, and multiple agencies involved. There was also, according to public reporting at that stage, no announced suspect and no charge in the killings. That unresolved space is not empty. It is the core tension of the case. This is what gives a channel authority, not a louder accusation, not a rush to declare the case solved before investigators do. Authority comes from showing viewers that truth deserves boundaries. A careful narrator can say, without hesitation, that the timeline is alarming, that the warning signs were serious, that the system appears to have faced clear signals before the deaths, and that the case raises painful questions about protection, risk, and accountability. A careful narrator can also say with equal firmness that public reporting had not yet announced charges or publicly identified a suspect in the murders. Both statements can stand together. In fact, they must stand together if the storytelling is going to remain honest. So this section does not pull the story backward. It strengthens it. It tells the audience that the case is tragic enough, disturbing enough, and meaningful enough to be handled without distortion. The line between suspicion and proof is not there to protect drama from the truth. It is there to protect truth from being bent by drama. In a real case, that line is part of the story itself. The public sees the warning signs and wants immediate certainty. The law demands evidence. Until those two things meet, a responsible script must carry both the urgency of the timeline and the restraint that credibility requires. The practical rule from here is simple. When the script names a fact, that fact must come from reporting, court records, or official statements. When the script describes concern, it should identify it as concern. When the script refers to what viewers may suspect, it should name it as suspicion, not conclusion. That approach does not make the case less gripping. It makes the channel more trustworthy. Viewers can lean in without wondering whether the story is quietly stretching the record behind the scenes. In a case involving children, grief, and a still open investigation, that standard is not optional. It is the difference between telling a difficult story with integrity and using a difficult story for effect alone. Because this case remained unresolved in public reporting at that stage, restraint protects the family from injury, hearing the story told in a way that pretends uncertainty has vanished, when, in reality, uncertainty was one of the heaviest facts anyone had to live with. The investigation had not yet produced public charges, but the legal consequences of December 3 began almost immediately. Death did not pause the machinery already surrounding this family. It redirected it. Within a day of the bodies being found, The conflict that had defined Charity Beallis's final year moved into another form. Not the fight to survive a marriage, but the fight over what the law would do now that she was gone. This is one of the harshest turns in the case, because it shows how quickly a human tragedy can become a battle over status, paperwork, custody of remains, and the legal meaning of a divorce hearing that had taken place only one day before the killings. The family was not allowed a clean line between grief and procedure. The two arrived together on December 4th, after authorities announced the deaths. Randall Beallis's attorney filed a motion to dismiss the divorce case. Reporting from 5 News, later echoed by KBTX and People, said the filing argued the case should be dismissed because Charity, the plaintiff, had died before the divorce decree had been formally entered. In plain terms, the position was that the marriage had not become fully final on paper before her death, and that the case should therefore end without the decree being completed. That filing matters because it transformed the question left hanging after the December 2 hearing into an urgent legal fight. The issue was no longer only what the judge had intended at the hearing. The issue became whether the law would treat Charity as a woman whose divorce had effectively been granted, or as a woman who died before she could become legally divorced at all. For John Powell, that distinction was not technical. It was personal, moral, and immediate. KBTTX reported that he went to court himself seeking to reinstate the case after a judge ordered an abatement because of his mother's death. He said he was fighting for his mother's justice and for the divorce case to be finished. That response is one of the clearest signs of continuity in this story. Charity had spent 2025 trying to create legal distance, custody protection, and formal separation. After her death, her adult son stepped into the vacuum and tried to preserve the legal meaning of what she had already fought toward. He was not trying to start a new battle from nowhere. He was trying to stop the existing battle from being erased by death before the law had fully written down its conclusion. That is why the phrase legal aftershock fits this part of the case so well. The violence had already happened. The investigation was active. Yet the family was now being forced to confront another injury, the possibility that the final hearing on December 1st would be stripped of legal effect because Charity did not live long enough to see the decree entered. A hearing had been held. Arguments had been made. A ruling appears to have been reached. But if the paperwork never matured into a signed final decree, then the law risked treating her effort to leave as incomplete. That possibility carried consequences beyond symbolism. It touched inheritance, marital status at death, and the meaning of the legal line she had been trying to cross. Estate and probate concerns sat underneath this fight, even when every article did not spell them out in detail. Once a person dies during a contested divorce, unresolved property questions do not disappear. They migrate. What might have been decided in family court can spill into probate court and estate administration, where the law has to determine who inherits, who controls decisions, and what happens when a marriage is left hanging between hearing and decree. Public comments from family members reflected that fear directly. In early coverage, Charity's relatives suggested that dismissing the divorce would affect who received what she would otherwise have obtained through the divorce. Even without naming every disputed asset, the basic issue was clear. Death had interrupted one legal route, and the family feared that interruption would change the distribution of rights and property that the divorce was supposed to settle. The court system added another painful complication. KTV reported that the Sebastian County Domestic Relations Division later released an order saying it did not have jurisdiction to rule on the competing divorce motions. That meant John was asking the court to treat the divorce as final, while Randall was asking the court to dismiss it. Yet the division handling the case said it could not decide those motions there. For a grieving family, a ruling like that can feel like another locked door. The question remains alive. The need remains urgent. But the place where you expected an answer says it cannot give one. So even the attempt to define Charity's legal status after death did not bring quick clarity. It produced another layer of uncertainty at exactly the moment the family could least bear more of it. But the most painful legal battle in the immediate aftermath was not about money. It was about bodies. On December 17th, a Sebastian County judge ruled that Charity's body would be released to her adult son for burial, while the remains of the twins would be released to their father, Randall Beallis. KTV reported the ruling on December 18th, and 5 News reported the same allocation the day before. That decision gave legal structure to one of the family's deepest fears, that mother and children would not be laid to rest together. The ruling also reflected the cold compartmentalization the law sometimes imposes after catastrophe. Charity was treated as one person with one next of kin question. The twins were treated as separate children with their own legal custodial line. The emotional truth, however, did not separate so neatly. For John Powell and other relatives, the mother and her children belonged together in death because they had belonged together in life. That separation became real by the end of December. People reported that Charity was buried on December 29th, 2025, without her twins, despite her family's wishes. John told the Daily Mail, as quoted by People, that it was sickening and heartbreaking, and that he did not even know whether the children had been buried, cremated, or where they were. Those remarks matter not for drama, but for what they reveal about the second layer of loss this family was forced to endure. First came the deaths, then came the division of the remains. Even burial, the act that often gives families a final place of unity, became another site of fracture. The mother was buried. The twins were not with her. The older brother was left grieving not only what had happened, but also the fact that he could not complete what he believed should have been the final act of dignity for all 3 together. This is also where the story's logic remains painfully consistent. Section 6 showed that the divorce hearing happened on December 2, but the decree was not yet fully finalized in the record before Charity died. Section 7 showed that the next morning brought the welfare check and the discovery of the bodies. Section 8 showed that the criminal investigation expanded while public answers remained limited. What follows naturally is this: because the decree was unfinished, the law had to decide what death did to the divorce, and because the homicide investigation remained unresolved, the family had to navigate burial and control of remains in the shadow of unanswered questions. Nothing here breaks the continuity of the story. It deepens it, the very legal incompleteness that made December 2 so terrifying became the reason December's aftermath was fought in court as well. There is another layer of cruelty in that sequence. A divorce is supposed to separate the living from one another under law. Here, the effort to separate legally was followed by a legal struggle over the dead. That reversal explains why this section lands so hard. Charity had spent the year trying to get out. After she was killed, her son had to fight to keep the law from acting as though she had never gotten out at all. He then had to fight over where she would be buried and accept that the twins would be released elsewhere. The family did not merely lose 3 people. They lost the chance for a clean legal ending, a clean burial ending, and any easy sense that the systems around them were capable of honoring what Charity had been trying to accomplish. John Powell's role in this aftermath is impossible to ignore. Earlier sections established him as the adult son who spoke of his mother's faith, defended her memory, and feared for his own safety while the investigation remained open. Here that same son becomes the person trying to preserve her legal position and her dignity after death. In that sense, he carries continuity across the whole story. Charity tried to protect her children and secure legal distance while she was alive. John tried to protect her name, her divorce case, and her burial rights after she was gone. The emotional logic is the same, even though the setting has changed from home and courthouse hearings to motions, rulings, and funeral arrangements. So this section is not a detour from the homicide story. It is part of the cost of it. The case did not end when deputies left the house on December 3rd. It kept injuring the family through court filings, abatement, disputed status, divided remains, and a burial marked by absence. That is why the legal aftermath matters so much. It shows that for families caught in violence, death does not always bring stillness. Sometimes it drags the survivors into one more courtroom, one more filing, and one more fight for what should have been obvious long before anyone had to argue it under oath. And in this case, Charity's effort to leave did not end with the hearing that should have freed her. It continued after her death in the hands of her son, who was left trying to finish what his mother did not live long enough to see completed. By the time this story reaches its legal aftermath, the audience has enough facts to ask the question that matters most: why do cases like this keep happening? That question has to be handled with care. It cannot become an excuse to flatten Charity Beallis into a lesson, or to turn her children into examples instead of human beings. But it also cannot be avoided, because this case carries warning signs that researchers, advocates, and courts have been studying for years. The value of telling a story like this is not only that people remember the names involved. The value is that viewers leave with a clearer understanding of danger, timing, and the limits of systems that often respond in pieces to a threat that is experienced as one burden. One of the clearest lessons is that separation can be one of the most dangerous periods in an abusive relationship. Research on intimate partner femicide found that women who had separated from an abusive partner after living together faced a significantly higher risk of being killed, and that the risk rose even more when the abuser was highly controlling. Another multi-year analysis using the National Crime Victimization Survey found that separated women were more likely than non-separated women to be victims of intimate partner violence, and that separated status had the strongest effect on risk in that study. Put plainly, leaving can be the right decision and still be the moment danger increases. That is not a contradiction. It is one of the cruelest realities of abuse. The attempt to create safety can trigger retaliation, control, stalking, or violence from a person who experiences separation as loss of ownership, rather than the lawful end of a relationship. That helps explain why Charity's 2025 timeline carries so much weight. She separated, filed for divorce. She sought sole custody and protection. She spoke publicly about danger. None of those steps should be read as overreaction. Now that the outcome is known, they should be read as actions taken during a period that research already recognizes as high risk. This is one place where public misunderstanding often causes harm. People sometimes ask why a victim did not leave sooner, as though separation automatically solves the danger. The research points in the opposite direction. In many abusive cases, the period during and after separation is exactly when the threat becomes more volatile. That means support cannot end once a victim leaves the home or files the papers. In many cases, that is when support becomes even more necessary. The second major lesson is why allegations of choking or strangulation are treated so seriously. In the February 2025 incident, public reporting said Charity alleged that Randall Beallis choked her. A major study published in the Journal of Emergency Medicine found that prior non-fatal strangulation by an intimate partner was associated with more than 6-fold higher odds of attempted homicide and more than 7-fold higher odds of completed homicide. The researchers concluded that non-fatal strangulation is an important risk factor for homicide and that it should be specifically screened for when assessing abused women. That finding matters because strangulation is often misunderstood by outsiders. It may leave little visible injury while still indicating a major increase in lethal risk. In everyday language, it means the violence has already come close enough to death that professionals treat it as a major warning sign, not just another assault allegation among many. This is why a case like Charity's should not be discussed as if the February allegation were merely old background. When a domestic abuse record includes alleged strangulation, it changes how the whole timeline should be read. It signals a level of control and physical danger that can escalate rapidly. It also shows why victims sometimes sound urgent in ways that other people dismiss as emotional or extreme. If a person has survived an event that researchers connect to sharply increased homicide risk, fear is not overstatement. Fear may be accurate. That is one reason public education matters so much. The average viewer may hear battery or domestic incident and fail to grasp what type of conduct is being described. The difference between a generic label and a strangulation allegation can be the difference between underestimating risk and recognizing that a life may be in immediate danger. A third lesson is how domestic abuse, children, and the legal process can collide in ways the outside world often underestimates. Charity was not trying only to end a marriage. She was trying to protect 2 young children while moving through divorce court, custody litigation, a criminal case tied to domestic violence, and later a no-contact order. Those processes may look separate on paper, but survivors do not experience them separately. They are parenting during hearings, planning safety around exchanges, measuring risk while documents are still pending, and trying to interpret what a court order means in daily life. When children are involved, every legal decision carries added weight, because the question is no longer only whether the adult victim can keep distance. It is whether the children can be kept safe, while the law decides how much access, authority, and contact will remain. This is where systemic gaps become easier to understand without turning the story into a lecture. Systems are usually built in segments. One court handles protection orders, another handles criminal charges, another handles divorce and custody. Investigators handle the homicide if the case later becomes one. Each part may do exactly what it is authorized to do and still leave the survivor living in the space between them. Arkansas law allows ex parte temporary protection orders and lets courts restrain an abusing party from injuring, mistreating, molesting, or harassing the petitioner. Arkansas law also says protection orders are enforceable by law enforcement, that violations can be criminal, and that officers may arrest without a warrant when they have probable cause to believe an order was violated and can verify the order. Those tools matter, but the existence of tools is not the same thing as seamless protection. in real life. A survivor may still face delays, fragmented communication, inconsistent enforcement, fear around child-related contact, or a process that recognizes risk on paper more slowly than danger develops on the ground. The CDC's prevention guidance points toward one practical answer: use lethality assessment and immediate advocacy earlier, not later. The CDC notes that lethality assessment programs can help police responding to domestic violence incidents screen for homicide risk using factors such as access to firearms, threats, and past violence, and connect high-risk survivors immediately to advocates, safety planning, and legal or medical support. That matters, because many cases do not fail for lack of concern alone. They fail because warning signs are recognized in isolation rather than combined into one risk pattern. A prior assault here, a custody fight there, a public warning somewhere else, a no-contact order in another file. And children inside the same home can remain separate pieces in separate systems, unless someone is trained and empowered to treat them as one urgent pattern. So the bigger lesson is not that every difficult divorce leads to homicide. It is that certain combinations of facts deserve to be taken with the highest seriousness. Separation after living together, controlling behavior, alleged strangulation, threats, access questions, custody conflict, and children dependent on adults for safety. When those signs gather in one case, the goal should not be minimal compliance with procedure. The goal should be active, coordinated protection that matches the level of danger. That is the value your audience should carry out of this story. Listen carefully when a victim says the danger is real. Do not assume leaving ends the risk. Do not treat strangulation as ordinary. Do not assume paperwork by itself creates safety. And do not mistake a system's activity for a system's success. In cases like this, the difference between those two things can be measured in lives. The lesson is not to blame victims for staying, leaving, trusting the court process, or asking for help imperfectly. The lesson is that abuse often intensifies around separation, that some acts signal greater danger than the public realizes, and that survivors with children are often carrying several legal burdens at once. When viewers understand that, true crime stops being passive consumption and becomes recognition. Recognition is not justice by itself, but it helps future warnings get heard earlier and taken seriously. In the end, this story returns to the same place where it first tightened around the audience, a house in Bonanza that would not answer. On December 3rd, 2025, deputies came for a welfare check at 9:30. No one answered. 2 workers helped officers get inside. Charity Beallis and her twin children were found dead with gunshot wounds. Those facts remain the fixed center of everything that followed. The investigation, the court motions, the burial dispute, the public frustration, the grief of John Powell, and the unresolved pressure hanging over the case months later. The house is where the public first learned something had gone terribly wrong. It is also where the story resists being reduced to paperwork, because every later filing still points back to 3 lives ending behind one silent door. But the house does not stand alone in memory. It stands beside a courtroom. The final divorce hearing took place on December 2nd, 1 day earlier. That 1-day gap is why this case stays lodged in the mind. The courtroom came first. The welfare check came next. Between those 2 moments lies the narrowest and most painful distance in the whole story. The distance between legal process and violent outcome, between the effort to secure a future and the collapse of that future before the law had finished writing down what it meant to decide. Charity had separated, filed for divorce, sought custody, sought protection, and spoken publicly about danger. Yet, the next morning still ended at the unanswered door. That is why the unanswered questions matter, but they must be named honestly. Public reporting showed a history of domestic violence allegations, a later guilty plea to third-degree battery, a no-contact order, Charity's public warnings in August, a final hearing on December 2nd, and the discovery of the bodies on December 3rd. Public reporting also said that investigators were serving search warrants, conducting interviews, and receiving assistance from multiple agencies, while not publicly naming a suspect or announcing charges in the killings. Those two realities have to remain together. The known facts are strong enough to show a pattern of danger. The unresolved parts are still unresolved. Responsible storytelling does not close that gap with assumption. It lets the audience feel the full weight of it, and the weight is heavy enough already. A mother warned publicly that lives were at stake, including the lives of young children. Her adult son later said she fought for months to save herself and the twins. The court system had already heard the case. Law enforcement had already entered the home. Investigators had already begun the longer work of warrants, interviews, and forensics. Even after all of that, the public was still left with the question that haunts many real cases. How much danger had been visible before the ending, and why did visible danger not become timely protection? That question is harder than the question of mystery alone. Mystery asks who and how. Warning asks why not sooner. That is the final frame this case demands. It should not be remembered only as a mystery. It should be remembered as a warning. Not every difficult marriage becomes lethal. Not every custody fight ends in catastrophe. But certain combinations of facts require immediate seriousness. Separation after shared life, alleged strangulation, children at the center of the conflict, public pleas for help, legal action moving forward, and a victim saying plainly that lives are at stake. Research and public health guidance already show why these signs matter. Separation is a high-risk period in abusive relationships. Non-fatal strangulation is treated as a major homicide warning sign. Systems may respond in separate channels, while victims live the danger as one burden. This case does not teach those lessons in theory. It teaches them through the loss of a mother and her children after months of visible strain. That is also why process alone cannot be mistaken for protection. There were filings, there were hearings, there was a criminal case, there was a plea, there was a no-contact order, there was a final divorce hearing, there was an active homicide investigation with search warrants and assistance from outside agencies. Yet none of those steps by themselves prevented the ending that now defines the case. But forms, orders, and appearances do not automatically create safety in the hours when a dangerous situation is changing fastest. When systems move in pieces, a victim can still be left carrying the whole risk at once. So the story closes where it began, with silence. not the silence of ignorance, because much about the danger had already been voiced, recorded, and argued. Not the silence of indifference, because a son, investigators, reporters, and a community all kept pressing for answers. It closes with the silence of a house that would not answer in time, and of a system that may have recognized pieces of the danger without stopping the ending. That is what makes the case so difficult to leave behind. The tragedy was not only what happened inside that home. It was the possibility that the signs had already been there long enough for someone to understand the risk before the door stayed shut. If there is a moral revelation here, it is not loud. It is steady, and it is hard. Truth can arrive before justice does. Warning can arrive before rescue does. Paper can record danger without removing it. And a person can do many of the things people say victims should do: leave, report, file, warn, ask, endure court, and still be left unprotected when danger reaches its final point. That is why this case should be remembered with humility. It asks viewers not to consume suffering as spectacle, but to learn how close warning and catastrophe can stand to one another when systems respond too slowly, too separately, or too late. So, when you think back on this case, do not think only of the mystery that remains. Think of the narrow gap between the courtroom and the house. Think of the mother who kept trying to move the law toward safety. Think of the twins whose lives depended on adults getting that safety right. Think of the son left to fight over his mother's legal status, and even her burial after losing all three. And think of the lesson that outlives every filing. Danger does not always wait for the process to finish. Sometimes it moves faster than the people trying to stop it. That is the quiet terror at the center of this story. And that is why real protection must be measured not by how much procedure exists, but by whether the vulnerable are still alive when the procedure is over. If this story interacts with you, subscribe to Bedtime Black Files, share it with someone who needs the lesson inside it, and leave a comment with the part that will remain with you the longest. Not because stories like this should be turned into noise, but because remembering warning signs can save lives. And in a case like this, the most respectful ending is not to look away too quickly. It is to carry the lesson forward with care.